The Supreme Court will be taking up a gun rights case.
The most significant case regarding the Second Amendment in more than a decade.
Members of the Senate are focusing on gun rights in the wake of the Supreme Court's Bruen decision.
Something just happened inside the Supreme Court, and it's about to change everything for gun owners across America. A 6-3 decision just dropped, and it didn't just tweak the rules. It torched the old playbook. From permits and background checks to carry zones and training laws, the entire system just got a seismic shakeup. If you own a firearm, a carry for self-defense, or believe in protecting what the Second Amendment guarantees, this ruling has your name on it. And if you don't know what changed, you could be caught off guard and caught in legal trouble without even realizing it. This is the new legal battlefield, and what we're about to walk through are the 10 rule changes every single gun owner needs to know right now. Disclaimer: I'm not your lawyer. This video is for information only, not legal advice. Gun laws are complicated and always changing. Make sure you follow your local laws and talk to a real attorney if you need help. Stay safe out there. Number 10. The 6-3 ruling that sent shockwaves across America. This wasn't just a court decision, it was an earthquake. The Supreme Court's 6-3 ruling just cracked the foundation of how gun laws have been enforced in this country for decades. And if you're wondering whether it matters to you, it absolutely does. At the center of this decision was one question: can the government force you through layers of red tape and make you prove you need self-defense before giving you your rights? The court's answer? A firm and final no. Building on the 2022 Bruen case, this ruling declared that your right to bear arms is not a privilege handed out by bureaucrats, it's a constitutional guarantee. From now on, if a law forces you to justify your right to carry, it's on thin ice. The court made it clear, the Second Amendment deserves the same respect as every other freedom in the Bill of Rights. And just like that, the legal playbook has been rewritten, based not on modern politics, but on America's historical tradition. This decision isn't just a win, it's the legal foundation for every 2A battle that comes next. Number 9. May issue permits just got buried. For decades, states like New York, California, and New Jersey played gatekeeper with your rights. Even if you passed a background check, took all the required training, paid every fee, they could still look at your application and say, nope, we don't think you need a gun. No crime, no red flags, just a personal opinion standing between you and your constitutional right. Not anymore. The Supreme Court didn't just criticize this system, it torched it, and May issue permit laws started falling like dominoes. New York scrapped its proper cause rule. California sheriffs lost their power to demand personal justifications. States like New Jersey, Hawaii, and Massachusetts quickly followed, either rewriting or walking away from their old laws. The result? America shifted overnight to shall issue. That means if you meet the legal requirements, the state must give you the permit period, because your right to self-defense shouldn't depend on a politician's mood or a bureaucrat's opinion. It travels with you, across county lines, across states, and it's not up for negotiation. Number 8. No more waiting games and why permits can't be delayed. For years, anti-gun states found a sneaky way to block your rights, not by denying your permit outright, but by dragging their feet until you gave up. You'd pass every background check, submit the paperwork, do everything right, and then sit in limbo for 6, 9, even 12 months. That's not regulation, it's obstruction. But the Supreme Court's latest ruling just made one thing very clear. A right delayed is a right denied. You don't have to wait half a year to speak your mind or attend church, so why should you wait that long to defend your life? Courts are finally treating these ridiculous delays as constitutional violations. In Massachusetts, Boston kept people waiting nearly a year until lawsuits forced change. Illinois saw the same. Gun rights groups had to sue just to stop officials from treating applications like they vanished in the mail. Now, judges are stepping in. If a state thinks it can slow roll your rights with red tape, the courts are starting to shut it down, and fast. Number 7. Mandatory training laws are on the edge. Some states tried a different tactic. They didn't ban your rights, they just made them too expensive and too complicated to use. Mandatory classes, multiple range sessions, costly certifications, hundreds of dollars and hours of your time just to carry legally. But that strategy is falling apart under the Supreme Court's new standard. The justices made it clear if a law didn't exist in the founding era, it's now suspect. And nobody in 1791 was required to take a government-approved training class before owning or carrying a firearm. That put states like Maryland, Illinois, and New York on notice. Maryland and Illinois demand 16 hours of instruction for a carry permit. New York upped the game after Bruen, requiring 18 hours. But courts are now hearing the argument that these aren't safety rules, they're roadblocks. Legal experts are saying it plainly. Training laws that are too long, too expensive, or designed to keep people out may violate the Second Amendment. The Constitution doesn't say your rights come with conditions, and once training requirements cross the line from reasonable to restrictive, they stop being legal and start being challenged. Number 6. Background checks must be fast and fair. Background checks have been a part of the process for years, but what the Supreme Court just made clear is that they can't be used as a backdoor to delay your rights. The system was designed to be quick. If there's a flag, the government gets 3 business days to sort it out. But in many anti-gun states, officials quietly added extra wait times, extra forms, and extra hoops, turning a simple check into a slow-motion rejection. Thanks to Bruen, those tactics are now under legal fire. Courts are beginning to say if the system is broken, slow, or full of errors, it's no longer constitutional. In fact, judges have compared some recent cases to nightmares, denials based on wrong information with no real way to fix them. California's 10-day waiting period and Washington's purchase limit rules are both being challenged because they have no roots in our country's history. The message is simple. You still need to pass a background check, but states can't use that process to wear you down or stall your purchase. If the government can't act in a timely, reliable way, it loses the authority to hold you back. Number 5. Bans on common firearms are falling apart. One of the biggest impacts of the Supreme Court's 6-3 ruling is how it's shaking up bans on popular firearms and magazines. For years, certain states have pushed hard to outlaw AR-style rifles and standard capacity mags, tools owned by millions of law-abiding Americans for self-defense, sport shooting, and home protection. But under the Bruen test, those bans are starting to fall apart. Courts are finally asking the right question. Are these firearms in common use for lawful purposes? And the answer keeps coming back the same. Yes, they are. That changes everything. Without a clear historical tradition of banning those types of weapons, modern restrictions are being ruled unconstitutional. That's already happened in California, where courts struck down the state's long-standing assault weapon ban. Illinois' newer semi-auto ban is now facing the same kind of legal pressure. Judges are recognizing that you can't erase a right just because a certain model or magazine makes headlines. When millions of responsible gun owners rely on them, and there's no historic precedent for banning them, the law is on the side of the people, not the politicians. Number 4. Sensitive places and the reality check on gun-free zones. After the Bruen decision, some states didn't back down, they got sneakier. Instead of banning guns outright, they started expanding sensitive places to cover nearly every corner of public life. New York led the charge, banning carry in subways, parks, restaurants, theaters, even on private property unless the owner put up a sign saying it was allowed. It was a clever workaround, but it didn't fool the courts. Because while the Supreme Court did say some locations like courthouses or schools can be restricted, Justice Clarence Thomas made one thing clear. You can't just declare entire cities or daily life sensitive to sidestep the Second Amendment. And federal judges took that seriously. One New York law that banned carry on all private property open to the public, struck down. A ban in Illinois that prohibited carry on buses and trains, also blocked. The principle is now locked in. The government can protect a few narrowly defined places, but it cannot use that excuse to wipe out your right to carry across most of public life gun-free zones. Can't be the default anymore. Number 3. States versus Constitution and the power of supreme law. The Supreme Court's 6-3 decision didn't just trigger lawsuits, it triggered a full-blown legal showdown between state-level gun control and the U.S. Constitution. Some states didn't take the ruling lightly, they doubled down. New York and California rolled out new laws loaded with loopholes, hoping to dodge the impact of Bruen. New York added vague, good moral character requirements, expanded its list of banned locations, and buried applicants in even more red tape. But federal courts weren't having it. Judges quickly stepped in to block or overturn many of these efforts, and in doing so, they reminded every state of a hard truth. You can't ignore the Supreme Court. You can't just reword a law and pretend it's something new. What we're seeing now is a real-time civics lesson. State legislatures don't have the power to erase a constitutional right. If they try, federal courts are stepping in. Fast, and that's a big shift. For years, gun control laws only seemed to move in one direction: tighter, stricter, more restricted. But now, the tide is turning. Every time a state pushes too far, it's met with immediate legal action, and Bruen is being used as the battering ram. Number 2, the Bruen test changes everything. One of the most important changes to come out of the Supreme Court's ruling is the new legal standard known as the Bruen test. Before this, courts used a confusing two-step process that often gave states room to argue that public safety outweighed your Second Amendment rights. But Bruen threw all of that out and replaced it with something much clearer. Now, if the Second Amendment covers your action, like owning or carrying a firearm, then the government has to prove that its restriction is consistent with how firearms were regulated at the time of America's founding. In other words, no historical tradition prohibition means no legal justification. This history-based approach has already started reshaping how courts evaluate gun laws. Judges aren't relying on modern crime statistics or policy arguments anymore. They're looking directly at how things were done in 1791, and many modern restrictions are failing that test. We've seen it play out in real cases. Maryland's handgun licensing law was struck down because the state couldn't find anything similar in the founding era. A Texas judge ruled that adults under 21 can't be banned from carrying handguns because young adults were armed back then too. The Bruin test is now the go-to legal tool for defending your rights. It's consistent, it's history-backed, and it's already helping gun owners challenge and overturn unconstitutional laws across the country. Number 1, the road ahead and why this fight is far from over. While the 6-3 decision was a major win for gun rights, it was also just the beginning of a much larger legal battle. Across the country, lawsuits are being filed using the Bruin decision as a foundation to challenge restrictive gun laws. Some are already winning, and many more are moving through the courts right now. But anti-gun states aren't giving up. Instead of accepting the ruling, they're trying to sidestep it with clever new restrictions, repackaging old laws with new wording, hoping they'll stick in places like New York and California. We've seen laws passed that add vague requirements, as expand gun-free zones and make it harder to carry, even after Bruin. But federal courts are pushing back fast, reminding states that they can't rewrite constitutional law with a few legal tricks. There are still huge questions ahead, whether bans on so-called assault weapons can survive, whether age-based restrictions hold up, and how courts will define sensitive places. Even the Supreme Court has said we're only in the early stages of this fight. At the same time, the ATF is under pressure for redefining what counts as a firearm and for its controversial rules on pistol braces. Constitutional carry is spreading rapidly, and the momentum is shifting toward freedom, but staying informed is more important than ever. The bottom line is this: the landscape has changed, but it's not settled. If we want these victories to last, we need to stay alert, stay engaged, and keep the pressure on. The courts have spoken, but the fight for your rights is still going, and this is only the beginning. We've broken down some of the most important legal changes gun owners have faced in years. Now I want to hear from you. What's your take on these new rules? Which ones affect you the most? And where do you think the next big legal fight is headed? Drop your thoughts in the comments. I'm always reading, and your voice helps shape this community. If you found this breakdown helpful and want to stay ahead of every court ruling, legal shift, and Second Amendment update, hit that subscribe button and join us here at Gun Law Updates. We'll keep you informed, prepared, and one step ahead as this legal landscape keeps evolving. Stay sharp, stay aware, and most of all, stay free.